Does a DUI have you bottled up? Are you confused and drowning in a pint glass of worry and confusion? We do DUIs here at the Marc Lopez law firm in the state of Indiana constantly. We built our reputation off of DUIs. A lot of people call asking questions as to, hey, what does this process look like? What am I about to get into? Am I going to go to jail? Am I going to lose my license? Do you have these worries? Well, let's try to break this down a little bit. So if you find yourself charged with a DUI, OVWI, OWI, again, all the exact same things, if you find yourself in that situation, you are likely trying to search for these answers. What does the process look like? Well, after an arrest is made, you either bond out of jail, you're released on your own recognizance, the court is going to set your case for what's called an initial hearing. Now, at the initial hearing, all that happens is a judge is going to read you what you're charged with, what the potential penalties are, and then they're going to address any potential license suspension. If there's a DUI involved, it is almost certain that your license will be suspended at that initial hearing, unless you can hire an attorney that can file the requisite paperwork to try to keep you driving while this case is pending. Now, there are other videos on our YouTube channel that discuss specialized driving privileges and driving while cases are pending, but the long and the short of it is very county specific and then oftentimes very judge specific, because keeping you driving while a DUI case is pending is entirely in the judge's discretion. Judge could say no because he doesn't believe in letting people drive while a case is pending. Judge could say no because he had a bad bowl of cereal. Judge could say no for whatever reason he wants. It is entirely up to the judge. But the initial hearing is kind of the kickoff to the entire case. In fact, I would argue the initial hearing is more important for the judge than it is the actual person going through the crime, because it's allowing the court to try to figure out what is going on as to whether or not you are hiring an attorney. Now, if you're charged with a misdemeanor and it's your first time, or you have some criminal history but it's way in the past and you're facing misdemeanor charges, an attorney will oftentimes waive that initial hearing. Why? Because of all the reasons I just said. Courts expect attorneys to discuss with their client what they're facing, what the penalties could be, what the strategies and defenses could be. So court allows the attorney to discuss that with the client and then not have to come in and take time on the court's calendar, and more importantly, take time out of your day where you could rather be working with your family or doing a million other things than sitting in a courtroom waiting for your case to be called, only for a 1-minute hearing for a judge to read a piece of paper to you about what you're charged with and what the penalties can be. So oftentimes getting an attorney involved early is going to be extremely beneficial for, one, waiving that initial hearing, saving you a little bit of time, but two, more importantly, trying to file the necessary paperwork to keep you driving while this case goes on. So after the initial hearing, whether you have it or not, the court is going to issue what's called a pretrial conference or a future court date. At that pretrial conference, in the old days, it was a time for an attorney, a judge, a prosecutor to sit down, hash out any issues that might be going on in discovery. Hey, Mr. Prosecutor, I still need body cam. Hey, Mr. Prosecutor, I still need the video from the dash cam. So it was very attorney, judge driven in the past. So a lot of counties these days are allowing that to be informal. There are still some counties that will require you to go in, whether it's to chat with your attorney, to show the judge that you're not a flight risk, that you're actually taking this seriously, to show up to court, things of that nature. But pretrial conferences generally are pretty quick. And if you're charged with a crime, whether it be DUI or otherwise, you don't say a whole lot. In fact, most of the talking is done by your attorney, the prosecutor, and then the judge giving you a future date. So there might be various pretrial conferences set throughout this process, trying to get us to the point of, okay, what's going to happen with this case? Is the case going to go to trial, or is it going to be resolved either by plea agreement or some other way? Ultimately, we're going to get to that point as to making a determination about how a case gets resolved. But here's a clue. Only you can decide how your case gets resolved. It is one of 3 things that you have ultimate say over in this case. Is, do I want to take a plea? Do I want to go to a trial? And do I want that trial to be by jury or judge? And then the last one being, do I want to testify at that trial if the case were to get to that point? So while this process is going, a lot of the intermediate stuff, whether it be pretrial conferences, status conferences, courts call them different, types of hearings, but really they're preliminary hearings, basically trying to give the judge an update on how things are going with the case. Some counties, again, they'll do it informally, meaning you do not need to be there. It's just between the attorneys. Some do it super informally, where myself or any one of my attorneys and the prosecutor can get together either by email, phone call, whatever, and fill out a memo for the court and let the court know. And then the court just kind of backs away because the court doesn't have any say in negotiations. The court doesn't have any say with how a case progresses forward. The only purpose at that point for the court is, one, to resolve any discovery disputes. Prosecutor's not turning over evidence. Defense attorney needs a certain type of video that the prosecutor hasn't given, or defense attorney's asking for a video but the prosecutor doesn't know if they have it or not. The judge would come in and can settle that dispute. And then ultimately the main control is, hey, this case getting a little bit old, let's get this thing set for trial, let's get this thing on the trial calendar or a plea agreement. We got to figure out something because we need to keep this case moving. So from initial hearing until the actual, what I call resolution day, it could be a trial, it could be a plea, there will be some various hearings. And there are times where you may need to be there, you may not need to be there, but during those preliminary hearings, the main purpose is just to inform the judge as to what is going to happen, how the case is moving. The interaction with you and the judge is very minimal to non-existent during those pretrial conferences, those status conferences. They just want to make sure that, number one, you show up. Number two, because you showed up, you obviously are invested and you're obviously taking this seriously. Then we get to the final, what I call resolution day, whether that be a trial or a plea. Now, the attorney's main job is to get to the point, I always call it the proverbial fork in the road, if you will. That's an analogy many people kind of understand is, I got to kind of get you to where the road goes two different ways. Number one, you can go to a trial. Number two, you can accept an agreement. We need to work on getting the best possible agreement, the lowest thing the state will ever offer, and then go over that. And if that's something that we accept, then we take the plea agreement path. If it's something, hey, I don't think this is worth taking, I think we need to take our chances at trial, or hey, Mr. Crows, I want to do a trial. Absolutely. Let's go full steam ahead down the trial road and let's get this thing fought to the end. No matter what, it is very important you have an attorney fighting on your side, and we love helping people. If you've got any questions or you find yourself in a situation where you don't know what's going on, you feel lost, that's okay. Give us a call. Let us help you feel better. Let us take that stress off you. 317-632-3642. And remember, always plead the fifth.